plead.
Okay, I'm not speaking to you, so you're going to have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We can't.
No need to
We
move
can't.
this any further because.
So here.
Subscribe for weekly courtroom stories.
Next, we're ready on the Schuster matter. Jonathan Schuster.
For the record, Abigail, this man was never appointed to me on my behalf. Like I told him the very first time I've ever met him, I'm here sui juris and propria persona. I reserve all rights. I, Jonathan hyphen Troy Fayetteville Colin Schuster, comma beneficiary and sovereign, and here for fraud, menace, and duress. Fiduciary, Abigail. This is a Social Security Sesticate Trust action, which you are now a real party and interest to. I'm here sui juris and propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is a commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is a Sesticate Trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud trust?
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I am here sui juris and propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or Sesticate Trust action. And so I'm here sui juris and propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris and propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead. I've
Okay,
never-
I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need
There-
to
we
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
it's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
argument.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July
That doesn't work.
1st.
That date doesn't work
Why doesn't it work for you?
because I'm a man. I have things to do. I've come here multiple times under duress with threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you
That-
don't come back on
Not
July
work.
1st,
Are you
then
threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't
Are
show
you
up. So
threatening me now?
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you
going
like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m. back in
Now
this
you're
courtroom.
threatening me. Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're going to threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you your
I'm telling
options.
you this matter needs to be dismissed with prejudice because you cannot prove jurisdiction. This is a
Signature here.
certificate trust action.
Signature here,
You're trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're
no,
done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more
Giving
so
you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed.
So for the record,
For the
the
record,
defendant's choosing to leave without his paperwork. He is expected to be back in court July 1st at 9 a.m.
Thank you, Your Honor.
We'll toll Speedy for that week.
Mr. Parent, you ready on anything else?
That was good.
Okay.
We appreciate you coming in.
Jonathan Schuster appeared before the judge for what was meant to be his first pretrial hearing, but the proceeding never progressed past preliminary matters because Schuster refused to acknowledge the court's authority in any conventional sense, opening by declaring he was appearing sui juris in propria persona, describing himself as a beneficiary, sovereign, and a non-U.S. citizen American national, and insisting the case was actually a trust or cestui que trust action rather than a criminal or traffic matter. He challenged whether his social security number was connected to the charges, and when the judge acknowledged that records existed in the system tied to his driving history, Schuster seized on this to argue the court was improperly treating what he claimed was a private trust matter as a commercial one, accusing the court of creating a bond against his trust without permission and suggesting this amounted to fraud. Throughout the hearing, he repeatedly demanded the court prove jurisdiction before the matter could proceed, insisting that failure to do so meant the case had to be dismissed with prejudice, a legal theory the judge firmly rejected, explaining that determining jurisdiction was not something owed to him in the way he was demanding and that the burden did not work the way he believed it did. When his court-appointed attorney, Mr. Parent, attempted to clarify the situation, Schuster interrupted him and the judge alike, refusing to let anyone speak on his behalf, while also refusing to give a straightforward answer about whether he wanted to keep his attorney, hire private counsel, or represent himself, instead repeating his sui juris declarations as though they answered the question. The judge, running low on patience, but remaining procedurally disciplined, ultimately decided to continue the matter for 1 week rather than force a resolution that day, scheduling Schuster to return on July 1st at 9 a.m. When Schuster objected to the new date, claiming he had already appeared multiple times under what he called duress and threats from the court, the judge clarified that failing to appear on the new date would result in a bench warrant being issued, a statement Schuster immediately characterized as a threat rather than a standard legal consequence. The exchange grew increasingly tense as Schuster accused the judge of violating his rights and continuing to commit fraud, at one point declaring unilaterally that the hearing was over and that he did not recognize the court's authority to keep him there, prompting the judge to clarify that if he did not take his paperwork and leave the courtroom voluntarily, he would be remanded into custody. To which Schuster responded by threatening to charge anyone who attempted to physically remove him with assault and battery before storming out without his paperwork. The hearing concluded with the record reflecting that Schuster left the courtroom under his own decision, and that he was expected to return for the continued matter on July 1st at 9 a.m. as scheduled, with the judge and Mr. Parent moving on to address other matters on the docket afterward.